Hi everyone, I'm S. Prakash, Assistant Professor, Department of Commerce, Dr. SNS Rajalakshmi College of Arts and Science. My topic is national and international in the cyber laws. So, any consideration of the international community's legal architecture, including the applicable to the activities in cyberspace, and necessarily begins with the Article 38 of the Statute of the International Court of Justice. The court, whose function is to decide in accordance with the international laws, such disputes as are submitted to it shall apply. The international conventions, whether general, particular, establishing rules expressly recognized by the contesting states. The general principles of law, the recognized by the civilized nations. The subjects to the provisions of Article 59, the judicial decisions and the techniques of the most highly qualified publicities of the various nations as subsidiary means for the determinations of rules of law. So, the national cyber laws, like India's IT Act 2000 and the US HIPAA, the focus on domestic cybercrime data protection. Example, unauthorized access fraud and e-commerce, while international cyber laws such as the new UN Conventions against cybercrime adopted December 2024, the provide global framework for cross-border cooperation against by cyber threats, harmonizing and definitions and procedures for investigation. Although the situated in the constitutive document of a single international tribunal, the article which tracks for formulation fund in the 1920. The next, the cooperation organization seldom qualifies in international laws because it is a aspirational and exordination in the nature but not compulsory. The codes of conduct or statement of the best practices are not binding on states in the same manner as legal norms, and their violation does not involve the same remedies. While the sanction of violations of international legal norms is complicated by the general absence of a compulsory enforcement mechanism, states are nevertheless significantly more the relevant and preach legal as opposed to the other types of norms. The national cyber laws examples. The India IT Act 2000 amendments provides a legal recognitions of for e-transactions deals with cybercrimes, the hacking, data theft, and stalking via Section 4366 mandates data protection for sensitive into sanction in includes new laws like the DPDP Act United States. So, the traditional norms of international law were viewed as binding only on the states. It was left to individual states to address the conduct of individuals and organizations that fell under their personal when engaged in activities that were within their subject matter's competency. The classic examples include international legal norms that permit universal justifications over certain acts such as war crimes. The nevertheless, to amount international laws, all such norms must be agreed to by multiple states either through treaty or the development of customary law. In the sense, the noted above the cyber internet crimes, intellectual property, electronic and digital signatures, and data protections and privileges, it is covered by the national laws. The key areas of covered national laws is the cybercrime, the unauthorized access, hacking, fraud, identity theft, child pornography. It is everything. It's true. The cybercrime. The next, data protection, the protecting personal and sensitive data. Example, health and financial. The e-commerce, legal validity of electronic records and signatures. the critical infrastructures, safeguarding essential services as the information. So, the next is the collecting of the international cyber laws in the framework. The Inconvenience Against Cybercrime, adopted in 2004, this landmark treaty aims to create common definitions, establishment common offense, and the set rules for investigating cybercrimes, including data preservations and protection orders. The Council of Europe, the pressure of the UN Convention focusing on international cooperation of cybercrime. The international cyber laws is the space. It is general principles to international laws like non-interventions being applied to the cyberspace, addressing state responsibilities for cyber activities through specific treaties in still development. Thank you.